So, anything to wrap up with, Mr. Hayes?
Well, there's one further document I haven't yet shown you, and I would like to show you, if I may. It's in the supplementary bundle beginning at page 372. Actually, I have shown it to you, now I remember, briefly on a separate point. 372 in the supplementary bundle.
This is the online factual accuracy.
Correct.
Yeah.
Yeah. And, bottom of page 372, the factual accuracy checking process allows you to tell us where information is factually incorrect, where our evidence in the report may be incomplete. The factual accuracy process gives inspectors and providers the opportunity to ensure that they see and consider all relevant information that will form the basis of CQC's judgments. The process also enables providers and inspectors to consider all relevant information that contributes to our judgments. Inspection teams base their judgments and ratings on all the available evidence. So far, I couldn't possibly object to how they set up their task. The question, I suppose, or one question, is whether information about steps taken since the inspection is relevant information. It's certainly available because it is to be found in the published report. But so far, one might be forgiven for thinking that that is information which is relevant and would be taken into account. Page 376 next. What you can correct halfway down the page. You can tell us if we've got any of our facts wrong using the form tell us about section C, additional information or information that was omitted which you think we should consider. But then over the page at the top, any additional information that you supply to support points in sections B and C must relate to the position at the time of the inspection. I ask, again rhetorically, why? Not explained. Second paragraph thereafter. The draft
Well,
report,
the answer may be Mrs. Justice Andrews' judgment, which deals with this point.
well, I'm going to come back to that
All right.
in a moment, if I may, because with respect, she was wrong, because she, and we know she was wrong, because we know that the CQC, far from drafting a report which doesn't reflect anything that's happened since the inspection, now published reports which include expressly reference to remedial steps that have been taken since the inspection. So, with great respect to Mrs. Justice Andrews, the report does not reflect only what the position was on the date of inspection, but she may not have been told that during the course of the hearing, which may explain why she said what she did. So, next paragraph but one, the draft report includes evidence collected on the day of inspection. You can also send us information about action you have taken since the inspection that addresses the concerns we raised with you, or which is included in the draft report. The inspector will consider any further information obtained and determine whether the report should be amended. Unless there are exceptional circumstances, this new information will not form part of CQC's decision around final judgments or ratings where appropriate. So, the provider is expressly invited to notify CQC about action it has taken since the inspection to address the concerns raised by the inspectors at the inspection. The inspector will consider any such further information and determine whether the report should be amended, but this new information will not be taken into account when the final judgments and ratings are arrived at. And that, we say, is frankly irrational. Indeed, it's incoherent, we suggest, and it's unfair for reasons I've indicated before the short adjournment. But why ever not? Again, I ask rhetorically, it makes no sense, and this self-imposed refusal to do so is not explained. Interestingly, that there's this reference to exceptional circumstances, which also is not explained. Now, if the provider has addressed satisfactorily a concern raised during the inspection so that that concern no longer applies, why is that not, again rhetorically I ask, an exceptional circumstance? Top of the next page, as a result of the factual accuracy check, the provider tells us that they've now implemented a policy. The inspector includes this information in the final report but does not consider it as part of the rating judgment. Again, why ever not? So those are the passages from the published, this is the policy, the self-imposed policy that the CQC has adopted, and I see it makes no sense. Can I then go to my learned friend's skeleton argument and finally address some further points raised in it, although the first one involves going back to section 61, which we looked at before the short adjournment. My lady, Lady Justice Laing, suggested, I think, that section 61 indicates clearly that what the report was to be about was a matter as expected, and thus would not include changes that have been made since the inspection. But as your ladyship and my lords have now heard and seen, on the contrary, the report does include express reference to changes that have been made. I haven't taken you to them because they're set out in my own friend's skeleton argument, but if you were just to look at the published report in the supplementary bundle, beginning at page 408, if you'd be good enough to turn it up. It's a little easier to understand the point I'm making if you can actually see it set out in the report itself. At page 413, under the heading "Are Services Safe?", third paragraph in, (413), my lord. So third paragraph down. During the factual accuracy period, the provider told us that following our inspection feedback, they had on 18th May ceased the prescribing of ramipril, lisinopril and angiotensin-converting enzyme inhibitors that require renal and kidney blood tests, and terbinafine, which requires a liver blood test. And then there's another change that had been made at the end of the next paragraph. Following our inspection, the provider wrote to us stating they would review the process of antibiotics prescribing to ensure it includes the necessary details prior to prescribing. So there we are. We know that the report does reflect and indeed expressly refer to changes that have been made since the inspection, and thus the CQC itself accept that section 61 does not restrict them to reporting only on what they found at the date of the inspection.
Well, they might be wrong about that.
Sorry, my lord.
I said they might be wrong about that. I mean, I'm not sure where this takes you, other than you're saying, well, the CQC do put in their reports, do reflect in their reports in accordance with their policy, changes that have been made since the date of the inspection. I don't know where that gets you as a matter of law.
Well, your latest first comment was you're not sure that the CQC are right about that.
Well, I don't know whether they are or they aren't. My question really is, how does any of this help you as a matter of law?
Because the CQC are fully prepared to refer to changes made, remedial steps taken since the inspection was carried out, but for reasons only explained at the very end of the skeleton argument, to which I will come in a moment, flatly refuse, they've imposed a blanket refusal to take any of them into account in their judgments and their ratings, which, for the reasons I set out in submissions before the short adjournment, we say is unfair.
But I'm puzzled because the example you've just taken, Stuart, this area, the first one, seems to me to suggest the opposite. So that is a cessation of prescribing of specific medications post-inspection.
Yes.
Now, you therefore have a scenario where on the inspection date the medications were prescribed, afterwards they've stopped doing it.
Correct.
Now, why is it unfair to base the rating upon what was being done at the date and not upon what happened as a result of a cessation, not only post-inspection, but evidently as a result of the inspection?
But because it's unfair to criticise and castigate the service provider if by the time that the report is finalised and published, the concern in question has been addressed. This is a report that's going to go to published to the world at large. By all means, it can say, when we inspected, this was the position, and it was unsafe. But it needs to be fair to the service provider. It needs to go on to say, but since then, they've stopped prescribing this drug.
And that is indeed stated, as you've shown. So what's unfair, given that it is expressly acknowledged? That's what I'm struggling with.
What's unfair, my lord, is that they refuse to take that change into account in their judgments and ratings. So they record it, presumably because they think it's important to record it. But when it comes to their final judgments and ratings, in this case, arrived at several months after the inspection, and set out in a report to be published to the world, they don't say, but in view of the changes that have been made, we do not consider that the service is unsafe any longer in this respect. I mean, again, I'm making my submissions by means of rhetorical questions, I appreciate it, but if they go out of their way to include the changes that have been made, it makes no sense not then to take them into account in arriving at their judgments and their ratings. And that's irrational on the one hand, and it's unfair on the other. Because the headline of the report that will go out is, this service is unsafe. Well, it may have been unsafe on the 17th of May, but by October, it's no longer unsafe. That's the point.
Can I just ask you one specific point on 413?
Yes,
The second example you gave us under 2, the last sentence. Following our inspection, the provider wrote to us stating they'd review the process of antibiotics prescribing to ensure that it includes the necessary details prior to prescribing. I mean, that, excellent, they're going to review it.
Yes.
It doesn't say they've reviewed it and come up with a new policy which has changed it. So that wouldn't have altered anything anyway.
Well, no, the CQC have expressly included that in the report.
Yeah.
So they must have attached some weight to the review that is to be carried out. They must have been satisfied that the review was to be carried out or had been carried out. Otherwise, no doubt they wouldn't have included reference to it in the report. And for all we know, if they'd taken that into account in their judgments and their ratings, they would have concluded that that was sufficient to meet the concern that they'd expressed. That we've expressed a concern about this prescribing. We've been told it's going to be reviewed. That satisfies our concern.
Thank you.
Can I then go to my own friend's skeleton? Page 38 of the core bundle. It's a small point, but my own friend says rightly that section 61(2)(b provides that the CQC must, without delay, send a copy of its report to the service provider. The section does not, in fact, say anything about the speed, as it were, with which the CQC must publish its report. I fully accept that the CQC will not wish to delay in publishing its report unduly, but the statute is silent on that, presumably because Parliament did not intend to make any specific provision about how quickly or otherwise the report should be served. And it could have done, of course, if it had wanted to.
No, what that refers to, I think, is the implicit statutory duty to get on and publish what you found out.
Yes.
I don't imagine you quarrel with that as part of the overall statutory scheme.
Thank you, Lord. Can I then come to the reasons, the only reasons given by the CQC for not taking into account remedial steps that have been taken since the inspection when they come to their judgments and ratings? And that's set out in 79.3 and 79.4 of the skeleton. Practical risks inherent in such a practice. Such an approach will incentivize a provider who has received an adverse draft report to seek to avoid critical findings by promising to implement changes to meet the CQC's concerns. Well, that's surely a good thing, not a bad thing. This raises the prospect of drawn-out negotiation following receipt of the draft report, with the provider seeking to stave off negative findings with promises to mend its ways and so on. Well, that may be true in some cases, but not in this case, because in this case, the changes, the remedial steps are all included anyway in the report. 79.4, even where a provider promises to take remedial steps, difficult to verify if such steps have been taken. So if they've been effective without undertaking a further inspection. Now, Lord, none of this we said.
They also refer in paragraph 80 to 2 paragraphs of Mr. Justice Andy.
Yeah, Milady, I'm just going to come to that.
I'm so sorry.
Next point.
Okay.
79.4, because the 79.3 and 79.4 provide the practical justification for not doing what we say they should do. And what we submit is none of this justifies a blanket refusal to take into account any remedial steps taken by a provider following the inspection. It may go to the separate question whether the CQC is satisfied in a particular case that such steps have been taken.
You took us to the policy, and the policy doesn't evidence a blanket refusal because you showed us that it refers to exceptional circumstances.
It does without telling us at all what it means by exceptional circumstances. Does it mean where remedial steps have been taken that do indeed correct the concerns that were expressed? Why shouldn't it? Why shouldn't that be exceptional circumstances? But it's and until we saw this document, and I'm not complaining that we didn't see it before because it's probably on their website. It is, but we'd always understood, and certainly it was put by a friend in the court below, that this was a blanket ban, and I don't recall him referring to exceptional circumstances. But it is subject to that, a blanket ban, and that is not justified by these considerations set out in 79.3 and 79.4, which, as I say, go to the separate question whether the CQC is satisfied about the steps that have been taken or not in the present case. As I've said, the CQC were satisfied that the appellant had taken remedial steps in the present case because they included them in the report.
But you're not challenging policies, I understand it, you're just challenging...
I'm challenging the policy.
No, you are challenging the policy.
Yeah.
You were challenging what happened in your case.
I'm challenging the policy as well,
Right.
which determined what happened in my case, namely the policy not to take into account remedial steps since the date of inspection in judgments and ratings. And that's why they weren't taken into account in this case. It was because of that policy.
Thank you.
So, lady, I do come next, therefore, to the paragraph 80 of the respondent's skeleton, which takes us back to paragraph 46 of Mrs. Justice Andrews' judgment, it's page 302 of the authorities bundle. The first point they make is that she said that the regulator is not bound to make findings on evidence that it did not see at the time of the inspection. But that was that's not the CQ's position. The CQ's position is that it simply won't even consider taking such evidence into account. Secondly, they refer to paragraph 49. The factual accuracy check is not intended to afford a further opportunity to reduce evidence that was not produced at the time of the inspection. Well, with respect, and this may well be because she didn't have that evidence before her, that's not correct, as your lordships and my lady have seen, because they do invite the service provider to adduce further evidence, and they do include reference to it in the report. And then finally, the passage that my Lord or Justice Arnold showed me before the short adjournment, earlier in paragraph 46. I also accept that the report reflects and can only reflect what was found at the time of the visit and not later. With great respect, perhaps for the same reason, that can't be right, because we know that it doesn't. On the contrary, it reflects material that became available subsequently and steps taken, remedial steps taken subsequently. Final point, your lordships and my lady will be relieved to hear, paragraph 81, the learned friends say, ultimately it's a matter for the CQC to determine what weight to place on particular factors. The court should accord the CQC as the statutory regulator a wide margin of deference, both as to its processes and as to its weighing of different factors and evidence. And they rely upon a passage in the care homes case of Mrs. Justice Beverly Laing, but that's not what she says. If we go to its Ideal Homes, paragraph 43, at page 344 of the authorities bundle, what she said was, second sentence, the court would afford an expert regulator a high degree of deference in terms of its findings and judgments. She did not say in terms of its processes and findings and judgments. Lord, those are our submissions on ground 2. Lords and my lady, I had some further submissions to make about relief, in particular about whether this court might consider deciding the substantive issues for itself, but I apprehend from some of the questions put to me that I need to overcome the prior obstacle of obtaining your lordships and my ladies' permission to proceed with grounds 1 and 2 as they now are.
Well, we'll hear what Mr. Stillitz has to say about that invitation.
In that case, perhaps I can come back to it in my reply.
If need be.
If need be. Lords and my ladies, those are our submissions.
Thank you. Mr. Stillitz.
May it please, lordships, your ladyship. I wish to go first back to the statute. Before I do so, I just make the overarching submission that in this case, the claimant invites the court, we say, to sort of micromanage and dictate to the CQC how it approaches its regulatory function in a way that goes well beyond what is appropriate and desirable given the CQC's statutory underpinning and function. But turning back to the statute, which is at tab 1 of the bundle of authorities, I'd like to pick it up, if I may, at page 6, which is chapter 2 of the Act, 2008 Act. Chapter 2 deals with the core registration functions of the CQC. And if one traces it through, one sees at section 12, the CQC must grant an application for registration where all relevant requirements are satisfied, although that may be subject to conditions. And under section 12.5, the CQC has the power to vary or remove conditions or impose additional ones. At section 17, which is page 11, the CQC has a power to cancel a registration. At section 18, page 12, it has a power to suspend a registration. Moving on to section 29, which is at page 26, the CQC has the power to issue a warning notice to a provider. And then at page 28, under section 30, it has the power to make an urgent application to cancel a registration, and that involves making an application to the magistrate's court. Under section 31, page 29, there's an urgent procedure for suspension or variation of conditions. And then at section 32, which is page 30, you will see that there is an appeal against any of those decisions that I've just highlighted to the court, other than the making of a warning notice. There's an appeal to the first tier tribunal. So if there's a variation of conditions, a suspension of any of those things, the provider has a right of appeal. I raised this merely to make a perhaps obvious point that procedural protection Parliament has decided not to provide in relation to inspections and reports on inspections. Those are in chapter 6, which begins at page 51, and the court's already been taken to. While we're in the statute, we would make the following short points. Power to conduct inspections is that under section 60, subsection 1. And the procedural requirements in relation to inspections are minimal under the statute. Under section 61, where an inspection is carried out under section 60, the Commission must A, prepare a report on the matters inspected. Pausing there, we pray that clause in aid in support of our argument that it is appropriate and consistent, and indeed arguably dictated by the statute, that the report must relate to the matters at the time of the inspection. And then under B, it must without delay provide that report to the person who carries out the regulated activity. We pray that in aid because that shows that Parliament intended that this should be a relatively swift procedure. Under subsection 3, the Commission must publish that report, and I would respectfully adopt my Lord Justice Dingemans' suggestion that it perhaps may be implied, given the previous subsection, that there is a premium on speed. And just while we're on that, the CQC's aim, I understand, is to publish reports within around 30 days of the inspection. That's its target. That wasn't reached in this case, and isn't reached in a number of cases. The main barriers to it are providers engaging in excessive factual accuracy comments In this case, it was 93 pages of submissions that they had to wade through. And the other factor, obviously, in this case, was that there's been litigation. And that's why there was an unusual delay. If you look at the chronology, it didn't take long for the CQC to send the provider the draft report. What took a long time was for it to wade through the lengthy factual accuracy comments and 39 appendices there too.
Do we? Is that in the bundle?
The factual accuracy comment.
Yeah.
No.
I've seen you refer to it. It's just I
No.
didn't find it.
It sounds like it's a bundle in itself.
It is. What one does have in the bundle is the CQC's response to the 93-page document.
I've seen that.
Which you will have seen, but I'm told that the original was 93 pages and had 39 appendices.
What,
And
sorry to interrupt, but
No.
just while you're on section 60,
yes,
whenever it's convenient to you, can you explain its interrelationship with section 46?
yes. Well, I'll attempt
Because that's also publishing a report.
Yes, I'll attempt to do that. It's not actually very clear on the face of the statute. Section 46 is at page 41. Section 46 is a broader power which enables the CQC to undertake reviews, and it doesn't need to be confined to an individual provider. It can be a review that's more broad than an individual provider. So it's a different power and less targeted. The inspection.
Well, presumably, past the point of Section 46 is that it empowers the Secretary of State to prescribe what the Commission does by regulations. Whereas that's not true of Section 60.
Yes, that I would accept that. But all I was really, in answer to my Lord Justice Dingemans question, I just pointed out that it's a broader power, that the inspection power is specific to the individual provider and is the more targeted one, and that's the one under which routinely the CQC does inspect providers.
And do the 2014 regulations prescribe anything at the moment?
No, the 2014 regulations are at tab 2. They don't prescribe anything by way of procedure. Just to briefly show your lordships and your ladyship those, if one goes to page 58, we'll see that at regulation 3, prescribed activities are those specified in Schedule 1 of the regulations. That's page 58.
And these aren't made under section 46?
So they are made under section 20.
8, 20, 35, yes. 86.
And the principal regulation making power does seem to be section 20 of the Act, because that contains the express provision.
So the power under section 46.2 has not yet been exercised. Sorry to ask these detailed questions
on that.
But Mr. Havertz has invited us to look at this, and we've obviously got to consider that application. Part of that will be whether we've got enough of an understanding of what's going on.
No, absolutely. I will take instructions on that point. Just finishing on the regulations, Regulation 8 contains the core duty under the regulations, which is that a registered person must comply with regulations 9 to 19 in carrying out a regulated activity. Those are referred to as the fundamental standards. Of key relevance here is Regulation 12, page 62, safe care and treatment. Care and treatment must be provided in a safe way for service users. And Regulation 17, which is at page 64, systems or processes must be established and operated effectively to ensure compliance with the requirements in this part.
I thought Regulation 11 was in play because one of your complaints, as I'd understood it or misunderstood it, was that the patient didn't have enough information about side effects. only would find that out if they read all the patient information.
Yes, and indeed that may well have, that might have been invoked, but it wasn't invoked. The only findings in relation to the regulations were specifically that there was a breach of Regulation 12 and a breach of Regulation 17. And just to complete, the schedule is at page 73. Schedule 1, the relevant paragraph is paragraph 4, which is page 74. Treatment of disease, disorder or injury. That's the relevant regulated activity in this case. And we make the point that the CQC has a wide range of powers in relation to its important regulatory functions, which can, in some cases, have very direct and serious implications for the carrying out of regulated function. The inspection power is at the lower end, at the bottom of the end of the range of activities and powers that it has, because inspection and reporting in itself has no direct consequences on the provider's ability to conduct a regulated activity.
Well, I think Mr. Havers would say perhaps it's a matter of legal rights and obligations, but in the real world, if you get a bad report, everyone's going to not invest in you, not use your services, etc.
Undoubtedly, a bad report can have consequences, and rightly so, because that's how the public and the market and so on find out about providers and what they do and how they do it. But it is one thing to have lower ratings. It's another one to be shut down, cancelled, taken to the magistrate's court, etc., which is not the sphere we're in at the moment. So that's the statute. In terms of turning then to ground one and the procedural unfairness point, we've made the point that the statutory scheme imposes no procedural requirements beyond what your lordships and ladyship have seen in relation to the publication of inspection reports, and that is in contrast to its other more draconian powers, which require judicial appeal or appeal to the first tier tribunal. And indeed, as my Lady Justice Laing pointed out, there's also under Section 20 of the Act and 27 a right to make representations in relation to proposals. So it's in contrast to all of those provisions. And we submit that it would be wrong in principle to impose onerous, complex procedural requirements upon the CQC in the production of its inspection report for the following 5 reasons. First, as the statutory regulator of the health and social care sector, the paramount function of the CQC is to protect the public, and it should be permitted to do that, as Parliament has entrusted it to do. Secondly, Parliament must be taken to have deliberately chosen to give the CQC a very wide discretion as to how to conduct its functions of inspection and reporting, given that it's not specified any at all, which brings me to a third point, which I've already touched on, that under other parts of the Act, Parliament has chosen to impose procedures for representations, appeal and so on, and therefore we submit that this court, or any court, should be cautious about implying additional requirements. Fourthly, the CQC is a specialised expert body which should be trusted, subject to public law principles, to undertake its duties with independence and diligence. And fifthly, those who use health and social care services are often vulnerable and in need, and they are entitled to full, robust and speedy information about regulated providers without the reporting process becoming bogged down in lengthy procedural wrangling or excessive legalism. And we do note that if one looks at the way Mr. Justice Mostyn summarised the claimant's proposed approach to the procedural question, that's paragraph 23 of his judgment, page 96, fourth on. That is quite an extravagant process to be implied into a statute. He spells it out accurately as eight requirements, no less. Paragraph 23, my lord.
Thank you, sorry.
The CQC inspection team sends the draft report to the provider. 2, the provider sends the CQC its list of alleged factual inaccuracies with reasons. 3, the CQC inspection team prepares its response to the fact list. 4, the CQC sends its response to the provider. 5, the CQC response, if not accepted, is not accepted by the provider, which then spells out its reasons in a reply, and at the same time seeks an independent internal review of the CQC's inspection team's response in the light of reply. 6, an independent reviewer considers the draft report, fact list, the CQC response, and the reply, and makes a recommendation. Pausing there, my learned friend has supplemented that requirement by saying an independent reviewer who is neither more junior than the lead inspector nor their line manager, otherwise it's presumably up to the CQC's discretion, at least to that extent. 7, in the light of the recommendation, the CQC inspection team then makes a final decision, and 8, the report is then finalised and published. And we submit that it's wholly unwarranted and extravagant to imply that Byzantine procedure into the Act. Now, I won't take up a great deal of time going through the authorities on Maxwellisation, as it's been called, because my learned friend has taken you to those.
Do you know the answer to the question I put to Mr. Havers about where this process of Maxwellisation came from? Because all the authorities set their face against it.
Well, it's something it's something of a misnomer, because obviously it's one of the contributions to the law of the late Robert Maxwell through his run-ins with the DTI. But in fact, what's implicit in my Lord's question is that if one looks at the Pergamon Press case and the subsequent Maxwell Department of Trade case, all those cases say is that there's a duty to provide the gist.
Well, the charge.
Yes.
That's what's said in the first case. And then in the second case, as my Lord pointed out, the Court of Appeal specifically rejected the proposition that you had to show the individual a draft of the report.
Indeed.
That was one of the things they were contending for, and that was specifically rejected.
Indeed, my Lord, and certainly my researchers and those of my junior have not revealed any case in which it has been said that procedural fairness requires the provision of a draft report. And my learned friend has not been able to refer the court to any such authority. And just pausing there, if that is indeed the case, already in providing a draft report in full, the CQC is going beyond the requirements of common law procedural fairness. And what is striking in all these cases we cite is that there may be a debate about how much of it is required for the purposes of gisting, providing some kind of indication of adverse findings. But nowhere in any of these authorities is there any suggestion that some kind of internal appeal, review, independent intervention is required. Lord Denning didn't say, oh, the DTI inspector needs to go to someone more senior within the DTI and get his responses checked. No hint of that anywhere in these authorities. And in our submission, for reasons I'll come to in a moment, that's where things did go wrong in the SSP Health case. I did want to refer briefly to just one of these cases, the Clegg case, which I don't think the court's been referred to, which is at tab 7.
Mr. Havers is right that there was a practice of sending the sort of relevant paragraphs of the reports.
Well, I would certainly not seek to contradict Mr. Havers on that, but we are dealing here not with practice. We're dealing here with what the legal requirements, the common law requirements of procedural fairness are. The decision of Mr. Justice Stanley Burnton in Clegg is another case about a DTI investigation under the Financial Services Act 1986 in respect of a company called Parkway. He refers at paragraph 38, page 245, to the decisions in Pergamon Press and Maxwell, and he goes on to quote from them at paragraph, in particular Pergamon Press, at paragraph 46. He then says at 47, in the present case, the inspectors decided on the nature and extent of disclosure to be made to Mr. Clegg in 1995, following Peter and Peter's letter of the 11th of August 1995. It is far too late to change that decision. I do not think that the conduct of the inspectors towards Mr. Clegg, taken as a whole, can be said to be unfair. He was given an opportunity to address the original provisional criticisms of him in writing following the letter of 25th of May 1995 and during the interviews. The object of the inspectors at the interviews was to elicit Mr. Clegg's evidence on the subjects of their provisional criticisms. And then at 50, Mr. Clegg complains that he was not given an opportunity to address the provisional criticisms in writing rather than orally. He points out correctly that it's the normal practice for company inspectors to submit provisional criticisms in writing and give those criticised an opportunity to address those criticisms in writing and in evidence. I think this is the practice to which my Lord refers. However, the normal practice is not mandatory. The Court of Appeal in both Pergamon Press and Maxwell stressed the need for the inspectors to be able to determine their own procedure within the constraints of fairness. It's important for there to be flexibility in the conduct of inquiries. And then at 51, furthermore, I agree with the guidance given in the investigation handbook published by the Department of Trade and Industry that once provisional criticisms have been provided to persons criticised and they've been given an opportunity to address them, it's unnecessary for amended provisional criticisms to be provided to them unless they contain new criticisms that the person concerned has had no opportunity to address. Company inquiries should be efficiently and expeditiously completed. If time and resources are devoted to maximalisation beyond what is necessary, company inquiries may become so unwieldy, prolonged and expensive that they lose their utility and cease to be commissioned. And we would respectfully adopt that policy reason given by Mr. Justice Stanley Burnton for avoiding excessive to and fro, which is precisely what the claimants would urge this court to endorse in the present case. So that's the Clegg case. You have our submissions in the skeleton argument on the other cases referred to, and then I turn now then to the decision in SSP Health. Now, the claimant in that case obviously was unhappy with the CQC responses to the factual accuracy points it had raised, and the question was as to what procedural fairness required in those circumstances. We do make the initial observation that the decision in SSP Health would appear to have been arrived at without the learned judge citing any authorities from the regulatory context at all. Perhaps surprisingly, only two judgments are referred to, two authorities are referred to anywhere in SSP Health, and they are not on point. If one goes to paragraph 53 of SSP Health, there Mrs. Justice Andrews refers to the decision in West and Parole Board, a decision on release of a convicted person's, revocation of a convicted person's licence. Well, completely different sphere to the one we're in, and it doesn't actually say anything more than a very general point that fairness, that the requirements of fairness are flexible and change over time. So that's not the case that's on point. And then paragraph 54, the learned judge referred to Abbey Mine Limited and the Coal Authority, which is a case about the grant of coal licences. And again, the passage cited is entirely general and says nothing whatsoever about any requirement in a Maxwellisation context for an independent internal review. And so it is, we submit, fair to observe that the decision in SSP Health would appear to have been arrived at without any regard to the relevant law in this area. Secondly, there is an assumption in the SSP Health judgment, and we submit an incorrect assumption, that a CQC inspector is, in any relevant sense, not an independent person. A statutory regulator is an independent person. If they have any interest in the outcome, then they must recuse themselves, but there's no suggestion of that here. The DTI inspectors are independent, CQC inspectors are independent. There is no relevant sense in which they are lacking independence. And there seems to be a confusion here between two aspects of public law. The area of public law we're in is the area of procedural fairness. That seems to have been conflated with some aspect of the law against bias or something of that sort. But there's no suggestion here that the lead inspector was biased or partial. And the fact that she would have been the initial author of the report doesn't prevent her being an independent person at all.
Can I just ask, was there any appeal against this decision?
I wasn't involved in that case. There's no suggestion that there was an appeal. My learned friend, although he says this is a point that's open to us, but he spent quite some time in his submissions saying this was opportunistic and why haven't we said this before and so on. But the reality is that the CQC responded to the SSP Health in a pragmatic way by putting in place the procedure that the court has seen. But that is very far from meaning that it accepts that it's legally required to do so. This is the first time this procedure has come before this court, the Court of Appeal. In my submission, it's not only open to us, but entirely appropriate that we make full submissions on what we say the requirements of procedural fairness are in this case. And indeed, Lord Justice Snowden, in giving permission, noted that there seemed to be inconsistent first instance decisions. And we asked rhetorically, what is the Court of Appeal for, if not to seek to clarify the law when it's become muddied, which we say it has been in this case, by a wrong turning in the SSP Health case. Now, turning to what was in fact decided in the SSP Health case, in my submission, what is absolutely clear is that it did not dictate that there should be the process that is now contended for by my learned friend. It certainly did not dictate that there should be a two-tier review where you have an initial factual accuracy review, that's then sent back to the provider, they then make submissions on the response to their factual comments, which is then reviewed by another, presumably more senior person. None of that is spelt out in SSP Health. The confusion, I suspect, may arise because Mrs. Justice Andrews was envisaging a situation where this review process would only come into play at all if it was requested. But the CQC, pragmatically, rather than waiting to see if there's a request, has simply built into its procedure a process whereby the lead inspector reviews the factual accuracy comments and routinely an inspection manager not involved in the initial site visit reviews them. Now, that may be good practice.
It's effectively quality assurance.
It's a kind of quality assurance, and it may well be good practice. But we would submit that simply because the CQC has chosen to adopt that good practice, that elevates it into a principle of law, as is suggested. Certainly, it doesn't elevate it to the sort of complex procedural requirements in stages that the claimant contends for in this case. And so we submit that SSP Health is a highly anomalous decision. It is not based on any of the established authorities on procedural fairness. It amounts to judicial legislation. In effect, Mrs. Justice Andrews was saying, well, Parliament hasn't said you need an appeal or a review, but I'm saying you do, and this is how it's going to be. And with the greatest of respect to her, that is not the role of the administrative court. And
what is, sorry to ask a technical question, what is the legal effect of the unappealed declaration made in that case,
well,
which purported to go beyond the case itself?
That is something of a mystery, for the reason that my lady, Lady Justice Laing pointed out that the judicial review application was apparently rejected, but a sort of bare gratuitous declaration was made in the terms set out in paragraph 69. Whatever its status may have been since then, the CQC has sought to abide by at least its spirit, but in my submission, that is an irrelevance at this point, because it is now a matter that's before the Court of Appeal, and to be clear, the CQC would welcome the clarification of the law in this field, because the SSP Health decision and its ambiguities have not been helpful to the CQC, or indeed the providers it regulates, in ensuring that they all know where they stand and what has to be done. So that's the best answer I'm afraid I can give, my lord, but it seems to me that we're, I hope, past that stage, whatever ultimately, whatever view this court takes as to what the law of procedural fairness requires.
And what do you say about Mr. Haber's invitation that we, as it were, grant permission to deal with this and then deal with it when there's already an outstanding listed judicial review on the 28th of March?
Well, and the pragmatic answer to that, I mean, one could approach it in that way. The pragmatic answer to that is that, having come thus far, I've taken instructions, and the CQC would welcome a clear ruling from this court on this point so that it just knows where it stands going forward.
Well, can we be very clear about how far that concession goes? Because, of course, if we decide that SSP was wrong, as you're inviting us to do, it doesn't make any difference to you, because if it's wrong, then it necessarily follows that ground one is not arguable. And it makes no difference whether we simply dismiss it as not being arguable or say, yes, it's arguable, but wrong. The outcome, so far as your clients are concerned, was effectively the same. Whereas potentially there is a difference if the boot's on the other foot and we say, well, it's right. And then there's a question potentially about whether then there's anything left to argue about on the 28th of March, at least so far as this issue is concerned.
Yes. Well, we don't shrink from the potential consequences of that, not least because our position is, to be absolutely clear, our primary submission is SSP is wrong and there is no basis in the law of procedural fairness for imposing any kind of review requirement. Secondly, if we're wrong about that and SSP Health isn't wrongly decided, in any event we complied with it, because properly read, all it was saying was that there should be some kind of independent quality assurance check on the response to the FAQ comments. And so either way, we say that permission shouldn't be granted, and this is not an arguable point. I don't think ultimately Babylon Healthcare and the Ideal Care Homes case take this matter a lot further. They were both permission decisions which didn't analyse the law in this area. We do adopt Mr. Justice Mostyn's critique at paragraphs 19 to 21 of his judgment of the approach put forward by the claimants, and reiterate that it would be very surprising, and we say heterodox, for the court to impose such a complex and onerous procedure on a statutory regulator where Parliament must be taken deliberately to have chosen not to do so. I turn then very briefly to the second ground.
So just before you leave that, can I just ask you this question? And your submission on the authorities, regardless of SSP, is that there is only a duty to give the gist or the element of the complaint to discharge fairness. Is that right?
Yes. Our submission on the authorities, on long-established legal principles, is that the relevant duty of fairness is to give a person against whom adverse findings are proposed to be made by a regulatory inspector the opportunity to comment on those findings or the gist of those findings before finalising them.
Well, can I just push you a little bit on that since we've got on to this question? I assume you would accept the qualification that I put to Mr. Havers and he accepted, namely that this is context specific. Now, does that not entail certain consequences in this area? Because if you're in the context of manipulating the stock market, it's quite easy to say to Robert Maxwell, the charge against you is you manipulated the stock market in the following broad ways. And you can summarise that in a broad way, and you don't have to descend too much into technical detail. Whereas here, we're concerned with the prescribing of medications, primarily medications which are themselves the subject of regulatory authorisation, but also a certain amount of off-label prescribing as well. And necessarily that involves consideration of a degree of technical detail, both from a regulatory aspect, and by that I mean a medical regulatory aspect, and from the aspect of professional competence within that particular realm. And it might be said that you can't really encapsulate that in a broad brush summary of the kind that you can do perhaps in the Maxwell type of scenario. What would you say to that?
What I would say to that, my lord, is that the more technical and detailed the adverse findings, the more that will be required, in fairness, by way of specificity, and therefore it may well be that where one is in a relatively technical area, effective gisting, if I can put it like that, requires that something nearly as detailed as, or indeed as detailed as, the report needs to be disclosed in fairness in order to meet the point that my lord makes. I would accept that, and therefore the reality is, if one's dealing with the CQC, Ofsted, these kinds of regulators, very often the practice is to provide a full draft of the report, and it may be that if fairness doesn't require that, it requires that the same level of detail is provided in any event. But, however, that's only to go so far, because what the authorities do not on any view require is any kind of internal review, and they certainly don't require the kind of multi-layered complex review that's proposed in this case.
Yeah, so your submission in a nutshell is that the most the law requires of you, even taking into account the technical context, is provision of a draft of the report. That's the very most, and a Housing Act type internal review is not required.
Indeed.
And what do you say to Mr. Haber's point, which is, again, within this medical context, with the possibility of an effect and the need to stop everyone charging to court, actually, when you've added on the FACs, which is an addition to what you say is necessary, it's really nothing just to require you to send back the FACs and allow them to comment and say, look, you've made the obvious errors.
In my respectful submission, that is a naive submission, with greatest respect to my learned friend. And the reason I say it's naive is that we know, when adverse reports are made by providers who have understandable commercial interests to look after and so on, this case is not unique in having seen a very extensive approach to factual accuracy at this stage. As I've already noted, what took up time here was not getting the report out, it was responding to the factual accuracy stage. And I have no doubt at all that if there was a further requirement to send back the initial factual accuracy responses for further submission, the second round of submissions wouldn't come in at 93 pages, but at 193 pages. And one would then be dealing with months with those. So I simply do not accept it as realistic at all to suggest that this would just be an extra 7 days and it would all be dealt with very swiftly. That, in my submission, is wholly unreal. But whether it is or it isn't, it's not what the law requires.
Thank you.
Now,
So you're going to move on to ground two.
yes, so ground two, which I think I can take more swiftly. In my submission, it's not that complicated. Essentially, the statute requires that the CQC makes a report of the inspection, and that's the state of affairs on the day. It is entirely proper for the CQC to give a provider the opportunity to say the state of affairs on the day is not what you were told it was or thought it was. So the example being, they ask for a policy, they're told there isn't one. When feedback is given, they say, oh, we did have one, we just forgot we had it. That's fine. That's all about what's going on the day. It's an entirely different thing to say, well, no, we didn't have a policy, but we're writing one now. That's got nothing to do with what happened on the day of the inspection. That's the provider trying to put their house in order. Very different thing. And you know, we just don't see that it's that complicated. And if there were any doubt about that, a worked example is given in on our website, on the CQC's website, which you know, draws precisely that distinction. If I could take the report to page 377 of the supplemental bundle. Halfway down, page 377, example of possible outcomes from a factual accuracy check. During an inspection, the inspector asks to see the copy of a safety policy. A senior member of staff tell them there isn't one. The inspector includes this information in the draft report, and it's considered as part of the rating judgment. CQC also considers the information when deciding enforcement action against the provider. Scenario 1. As part of the factual accuracy check, the provider sends this policy to CQC stating that it did exist at the time of the inspection, and they don't know why the senior member of staff told the inspector they didn't have one. The inspector is satisfied that the document was available at the time of the inspection, so includes this information in the final report, and it is considered as part of the rating judgment. CQC also considers the information when deciding whether to take enforcement action
And we
against
can
the
see
provider.
that scenario is based on the SSP case.
Yes, and rightly so, because one's looking at a snapshot on the day of the inspection. Scenario 2, as a result of the factual accuracy check, the provider tells us that they have now implemented a policy. The inspector includes this information in the final report, but does not consider it as part of the rating judgment. CQC also considers the information when deciding whether to take enforcement action against the provider. Now, in my submission, it's to the CQC's credit that it, when it's told by a provider that they've taken remedial steps, they put that in the report so as to you know, ensure that due recognition is given to that. But it's entirely rational and indeed in line with the statutory requirement for them to base their ratings and judgment on what the position was on the day of the inspection. That is what section 61 of the Act requires. And in my submission, it's what is inherent in the idea of a day of an inspection on a particular day, and indeed, moreover, we would submit there are serious practical difficulties in adopting any other approach, because CQC inspections are supposed to be conducted and reported on swiftly, and if there is a subsequent to and fro, that will impact on that. The other point to know is where an adverse report is made, the CQC's policy is to re-inspect quickly, normally within about 6 months, and then any remedial steps can be taken into account at the next inspection. The reality is that if the approach were not to simply look at the position on the day of the inspection, but to give the provider the opportunity to mend its ways following the inspection, one can see all sorts of practical difficulties arising, because then one gets into a sort of back and forth where the provider says, well, we're sorting this out. Well, how long do you give them? How do you verify that they really have? How do you then identify the date of the inspection? The reality, again, is that it would be naive to think that it would involve anything other than providers pulling out all the stops to try and stave off an adverse report, trying to slow the process down and avoid the adverse findings that were justified by what the position was on the day of the inspection. The further practical point is, how does one tell if the remedial steps have been taken, and if they have been taken are effective? The passages in this case are deliberately couched in terms of a certain degree of circumspection, because just to take the different, this is paragraph 77 of our skeleton, paragraph 77.1, which is page 37 of the core bundle, the provider told us that following the inspection, they had an agent may cease the prescribing of ramipril, sunapril, and angiotensin converting enzyme. Now, it said they told us because the CQC can't verify that till its next inspection. At 77, last sentence of that paragraph, following our inspection, the provider wrote to us stating they would review the process of antibiotics prescribing to ensure it includes the necessary details prior to prescribing. Well, that's great as far as it goes, but until you've seen their review and what it achieves, it's very difficult to reach any concluded view on the findings and ratings. Again, at 77.3, following our inspection, the provider wrote to us stating that they had taken action to correct this, and so on. And indeed, at 77.4, it's even more circumspect. Following inspection, the provider told us they'd risk assessed the medicines we'd identified as concerning during the inspection and had temporarily ceased prescribing these medicines. However, the provider has not provided us with any further risk assessments to evidence this. So the CQC is being extremely fair to the provider there, and say, including in its report what the provider is telling it about the action it's taken. And that may be relevant in particular to whether enforcement action should be taken, because if you have a provider who's showing a real intent to mend its ways, you may take the view, well, we're not going to cancel its registration, we're not going to issue it with a warning notice, we're not going to take any of the other steps we can, because we can see they're trying and that they're in good faith about that. So it may be relevant to enforcement action, but it's not relevant to the inspection of the service on the day it was undertaken. And in my submission, it's not simply that it was open to the CQC to adopt this approach. In my submission, it would be surprising if it adopted any other. And that really brings me to the final point that we make, which is that, as Mrs. Justice Beverly Laing noted in the Ideal Care Homes case, this is an area, and this is really where I started, this is an area where the CQC should be given a high degree of deference, as she puts it, in terms of its findings and judgments, citing the London and Continental Stations case, and the level of prescription and criticism that this claimant levels against it is nowhere near an appropriate level of management of the CQC's approach to its role, certainly in terms of what's required by the principles of public law. My Lord, in answer to your question about regulations made under Section 46, I understand regulations have been made under, and they are the Care Quality Commission Reviews and Performance Assessments Regulations 2018, but I understand that they don't prescribe any procedures, and they deal only with which service providers and regulated activities are prescribed for the purposes of Section 46. That's all they deal with.
And how do we know that this was a Section 60 rather than a Section 46 inspection? I mean, I'm sure you're right. It's just I couldn't work it out.
Simply because I asked the same question myself, and simply because I am told that is the power that the CQC undertakes these sorts of inspections pursuant to.
Thank you.
Yes, and indeed, further points made by Ms. David Jr. that in fact the CQC regards Section 61 as one means of discharging its Section 46 duty by using its power to inspect to fulfil its duty to conduct reviews. Unless I can assist the court further, those are submissions on behalf of the...
No, thank you very much. Any reply, Mr. Holmes?
Yes, my lord, but only a few. Firstly, the statute. My own friend took your lordship's, my lady, to the various provisions relating to registration. I don't need to turn it up, they all appear in a different chapter of the Act to the chapters with which your lordships and my lady are concerned. They all appear under Chapter 3, which sets out a detailed procedure for applying to be registered, the registration process itself, and so on. Parliament has chosen to make detailed statutory provisions for registration, but to leave it to the CQC to lay down its own procedure for inspections and reporting. But that procedure must, of course, still be fair. So the fact that Parliament has chosen to make detailed provision in a different part of the Act in relation to a different part of the process, that's to say registration, doesn't, we submit, assist your lordships to conclude one way or the other that what Mrs. Justice Andrews did in SSP was right or wrong. Lord, secondly...
Sorry, just before you leave that,
yes,
I think you said Chapter 3. Did you mean to say Chapter 3?
I think I did, but
because
well
it's only registration I had as Chapter 2, and then that may be my unfamiliarity with
the own friend took you to... was it Chapter 2?
Yeah, page 6.
Page 6. I'm so sorry, yes.
No, don't worry. In which case, don't...
The point's the same.
I understand the point. I just was worried I'd missed a chapter.
No, for 3, read 2, if your lordships will be so kind.
Thank you.
Next, my own friend described the procedure that we contend for as extravagant, complex and onerous. Can I just ask you please to turn up paragraphs 18 and 19 of our skeleton argument, page 7 of the core bundle. where we set out in paragraph 18 the procedure we contend for, and in paragraph 19 the procedure adopted by the respondent. So 1 and 2 are the same. Service provider receives draft report and 2 submits FACs. Under the current procedure, step 3 in paragraph 19, the lead inspector considers the submissions and sends them to the independent reviewer. In fact, in this particular case, she then sent the next draft of her response back to the reviewer for a second review, and the reviewer provided approved the response, I should say, on the 16th of September. So that's paragraphs or steps 3 to 6. And then the appellant received one response along with the final report on the 20th of October. That's step 7. Whereas what we contend for is none of that, but instead our step 3, the inspector sends her response back to us. The service provider can request an independent review and set out why. The independent reviewer then considers the materials, but he or she only needs to consider the draft report, the FACs and so on, for the purpose of deciding the points we raise. So he or she is not expected to conduct a full review of all that material, but only to look at it to the extent that it's necessary to do so to address the points raised by the service provider. And then the final response and report are sent to the service provider. With great respect, it's difficult to see how any of what we suggest as set out in paragraph 18 could be described when compared with the procedure actually adopted. In this case, in paragraph 19, could be described as complex or onerous or extravagant. Next, you were taken to the decision in Clegg. My Lord, can I take you back very briefly to the report starts at page 236 in the authorities bundle. You were taken to paragraph 50 and 51. And at the end of paragraph 51, Mr. Justice Stanley Burton says that company inquiries should be efficiently and expeditiously completed. Time and resources are devoted to maximisation beyond what is necessary. Company inquiries may become so unwieldy, prolonged and expensive that they lose their utility and cease to be commissioned. None of that could conceivably be said to apply to the procedure that we contend for in the present case. Next, my own friend says that SSP, that there's nothing in the authorities that dictate that there should be a 2-tier review, as Mrs. Justice Andrews found. Can we just be clear what my learned friend is referring to? Tier 1 is the FAC procedure already built into the CQC's procedure. The second tier is simply the additional layer review that she said should apply, which simply takes us back to the question, did fairness require such an additional layer of review? And then finally, my learned friend suggested an apocalyptic scenario in which, take this case, if the appellant in this case was allowed the opportunity to request a further review and allowed the opportunity to make some representations about why it regarded the response as inadequate or defective, the CQC would be faced with not 97 pages, but 197 pages in support of that proposition. But the short answer, as I indicated this morning, is for the CQC to limit the amount of material that the service provider is entitled to put in support of its request for a review. There could be no complaint about the CQC doing so, and all it needs to do is to do so, in which case there won't be anything like 197 pages. As I said, if they say 2 or 3 pages, it will have to be. And then finally, my own friend...
But how can that be realistic if what's being... I mean, Mr. Stillett in his submissions realistically accepted that what would have to be served in many cases might well be the whole report, virtually the whole report. How's it realistic for the CQC to say, well, I want 3 pages of comments on the whole report? It would cause uproar.
Unfortunately, not. That's certainly not what I'm instructed by by the appellant.
All right.
On the contrary, they simply want that opportunity, and they would be perfectly content if the opportunity was restricted to, say, 2 to 3 pages of A4 or whatever the electronic...
2 to 3 pages of A4.
Yes.
All right.
I mean, at this stage of the exercise, brevity and conciseness are plainly called for. And as I said, they'd be perfectly content to accept a time limit of 7, 10, 14 days in which to prepare it and submit it. And that's the short answer to my own friend's complaint. As to ground 2, all I want to say is this: my own friend spent a little time explaining why he said our procedure would be simply unworkable. And he picked up some of the points that my Lady Justice Laing had put to me this morning. But that doesn't answer the overarching complaint which we make, which is the blanket ban which the CQC has imposed on itself. A ban on taking into account subsequent remedial steps in its judgments and its ratings. Entirely up to the CQC to say, well, you tell us this, but we're not satisfied, we haven't seen enough proof, we don't accept it, we're not taking it into account. That's a matter for them, but that's no answer. It's no answer to the primary submission, which is the blanket ban is irrational and unfair, to say, well, it might turn out to be difficult to work in practice. Finally, back to relief, my own friend has indicated that the CQC would welcome a substantive decision of this court on at least ground 1. I was going to say something about why we would encourage this court to provide a substantive answer on ground 1. And can I just briefly, I hinted at some of the reasons why we say that. Can I simply add to those reasons this? Firstly, the costs if your lordships decline to do so, and it may be maybe your lordships will refuse permission altogether on both grounds, in which case that's an end of it. But if your lordships were to grant permission on ground 1 and or ground 2, but not then to decide the substantive issues yourselves, then we go back to the administrative court, whether there's time on the 28th of March to tack on those 2 grounds or not would remain to be seen. It may be that hearing would have to be put back in order to find time to do so, because I think only a day has been allowed for it for the moment. But there would be the additional costs involved in debating those issues before the first instance judge, and there must be every prospect that whoever loses on those grounds will then appeal against the first instance judge's decision, and we'll find ourselves back before this court, advancing the same arguments that have been advanced today in support of one side or the other. And that, as I say, will inevitably increase the costs of the overall exercise very considerably, and it will increase the time taken before a definitive answer is forthcoming from this court. And that leads me to my second point, which is that given that these two grounds raise issues of some importance, in particular the first ground, where there are differing first instance decisions, as Lord Justice Snowden acknowledged when he granted permission, page 41 of the Court of Underlaw, the sooner we submit this court pronounces on certainly ground one, and we would say ground two as well, the better for all those concerned. And there are plenty of those who are concerned, and not just the CQC who are concerned in all these cases, but they regulate a large number of different entities. These two grounds apply in principle to their procedures and their policy in terms of their regulation of those entities. So we would urge those considerations on your lordships and my lady in support of our invitation to you to decide the grounds substantively. Unless we can assist your lordships and my lady further.
No, thank you very much. Well, our thanks to both sides for their submissions today. We will consider them and produce our judgments in due course. They will go out, as is normal, in draft for you to correct our spellings, other typographical errors and elementary factual errors like dates, but not to re-argue the case. And as I'm sure everybody in court is now well aware, the drafts will go out under a strict embargo, which must be strictly observed, and there are potentially serious consequences if it is not. Once we have received your hopefully minor corrections to the drafts, there will then be a remote hand down which will not require any further attendance from the parties. As well as providing corrections, please can you see if you can agree between you a consequential order. If you can't agree a consequential order, please make brief written submissions on any points that are in dispute, and we will determine them on paper. Thank you again.